Hey folks, how's everyone doing today?
Good, how are you?
I'm doing well. Thanks y'all for having
Of
me
course.
here again today. Always appreciate everyone's time and just everyone being here. I know at the last conversation we had, Janine mentioned having a Know Your Rights workshop for y'all. So I'm gonna do a crash course on your rights as a tenant in California. Some of this might apply to you, some of it might not apply to you, but it's always good to know this information just in case you're going through some issues yourself, you have family that's going through these issues, and you can detect whether what you're going through is legal or illegal, or at least start to have some type of sense of your rights as a tenant. And we can go ahead and get started, Janine. So I did want to start off with a disclaimer. This presentation contains general information about your rights as a tenant. The law is complicated, and that is on purpose. The law is not meant for everyday folks the way it is written. So not, like I mentioned, not everything will apply to you, and the law shouldn't be complicated, but unfortunately it is. This presentation is not legal advice. I am not a lawyer. So I am giving you resources for y'all to have, but this is not legal advice. If you can please speak with a lawyer who can provide you with advice about your specific situations. Every situation is different, and every situation will have a different outcome and solution to it. And we will be providing some resources at the end of this presentation for folks who might want to talk to a lawyer, but this is just general information. Next slide. So first, housing is a human right, right? Housing first, the law is unjust and it does favor landlords. But you as a tenant have a right to know and assert your rights. And you can also organize to change the law. Laws are always changing, laws are always amended. And so if you believe everyone should have housing, please, 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 use your voice to change these laws, but the law is unjust and it does favor landlords. So this is our agenda for today. Will be a presentation. I'll stop in between for Q&As. Like I said, some of this is complicated. So I will be stopping in between sections, or feel free to please write your questions in the comments if you want to go into something into more detail, or just have questions about a specific portion of the presentation. Next slide. So it'll start off with moving in, your rights when you're moving in, your rights once you are living in the unit, your rights once you're moving out of the unit, and then some COVID programs and laws that passed when COVID took a hit on a lot of communities. So we'll start off with the very basics. Get everything in writing. Why do we get everything in writing? In case you have a disagreement with your landlord, or in the event that you are taken to court, which often happens to folks, and they don't have anything written, they don't have any evidence. So it's always important to get everything in writing. It is important to get your lease, your security deposit, any request for repairs, moving in and moving out inspections, or any important communications or events in writing. It is always better to have everything in writing. If it's mailed to you in writing, it is just best to have everything and every possible piece of evidence you have in writing. Yes, keep it in a safe folder, keep it somewhere where you can easily access it. Next, you have a right to translated documents. If you negotiated your lease in any one of these languages, then your landlord has to provide you a copy of that lease in that language. And they have to provide you with any other notices in the language that you negotiated your lease in. A lot of times, I hear from folks that they negotiated their lease in English because they had their child there to translate. And so technically they negotiated their lease in English because their child was talking for them in English, which oftentimes gives them the benefit to then start to give every notice in English. So I always recommend negotiating your lease in your native language so that you can get your lease and any other notices in your native language. Immigration status. In general, landlords can't ask about your immigration status. They cannot ask tenants, prospective tenants, or occupants about their citizenship or immigration status, or require them to produce documents proving their legal status in this country. The law does provide for an exception for some landlords to require citizenship status, but that is only if where you're living has federal government programs to them, such as rental assistance that's federally provided, such as Section 8, or other programs such as that provide that you disclose your immigration status. But other than that, they cannot ask you for your immigration status. They also cannot terminate or evict a tenant based on what the tenant's immigration status is, whether that is what it really is or whether that is just what the landlord is perceiving it is, or that someone with whom they associate with. They can't ask you any of those questions. They also cannot disclose or threaten to disclose to any third party, which might be ICE, and also includes law enforcement, what they perceive your immigration status to be, whether you're a tenant, a prospective tenant, or someone who's already occupying the space. Again, any exception exists in the event that the landlord reveals this information in order to comply with legal obligation under federal law. That means that there's a warrant out for someone, or there's an order issued by the court that then allows them to disclose this, but other than that, they can't. And one other reason a landlord might be asking for your immigration status is if you have applied to become a manager for that building, because you need to fill out certain IRS forms to be able to work and prove that you're able to work. So that's the only other reason they might ask for your immigration status. Next slide.
Carla, there's two questions in the chat.
Okay. A child can be used as a translator. Unfortunately, a lot of folks use a child as a translator when translating their leases. I don't think, I personally don't think there is a law that says that for these specific instances, you need a translator to be over 18. But again, I mean, there is also not a requirement to have the landlord to have a translator there, if someone brings their own translator. So I can also get back to you on that question. Like I mentioned, I'm not a lawyer and the law is complicated. So some of these questions I might not be able to answer. What if they request a social security number for applicants? They request it as, this is where it gets complicated. Are they requesting it to apply to a regular apartment building? If that's the case, they could ask for it, but you're not required to give it to them. Sometimes they ask for it just for a credit check. In that instance, then folks can give an ITIN number, an individual number taxpayer. I believe that's what the acronym stands for, but I'll put it in the chat. It's called an ITIN, an individual taxpayer number, that folks can give and that a lot of undocumented folks do use, but they can't request a social security number for applicants unless, like I stated, it's part of a federal government or it's Section 8 housing. and things of that sort. So this was where I was gonna pause for questions, but does anyone else have any other questions?
Yes, I have a question.
Yes, go ahead, Larry.
I was wondering if a landlord can tell you if you can smoke if you smoke cigarettes, or if they can tell you can smoke, you cannot smoke in your apartment.
Like, is the landlord allowed to tell you if you can't smoke in an apartment?
Yes.
If you're living in the city of Fresno, there is an ordinance that says that multi-unit complexes, folks are not allowed to smoke inside of their units. So there is an ordinance in Fresno. I'm not sure if you live in Fresno or not.
Yes, I do.
Yeah, so in the city of Fresno, they can absolutely tell you to not smoke inside of your units, and they should have a designated, or you should go outside to an outdoor smoking area. But the landlord is allowed to tell you that you can't smoke inside of your unit, since it is an ordinance in the city of Fresno that passed earlier this year through city council.
Yeah, I was a little surprised on that. I pretty soon we're gonna say, can I go to the bathroom? We have to raise our hands. No, I was just curious. I mean, yeah, because it seemed like you pay the rent. Well, why can't you do what you do at your house? I was just thinking about that.
Yeah, and it pertains to any substance. You can't vape, you can't smoke marijuana in your home. Any substance that you smoke would have to be in a designated smoking area. Because we're dealing with that here at our apartment complex right now.
Okay, I just got a notice on that, and I said it don't make no sense. I rent the apartment.
Yeah. Well, you have to think of the health and safety and well-being of other tenants, because secondhand smoke, your neighbor next door, you know, they don't need to be exposed to that because they don't choose to smoke for their health. So it's just,
everybody in the apartment smoked.
no.
In my apartment, there's only like 10 of us.
Well, yeah, to answer your question, yeah, that they can tell you no, and there is an ordinance put in place, like
Okay,
Kara mentioned.
I just wanted to confirm that. Yeah, 'cause I was a little skeptical on that. I was about to tell him something, but I said, well, I better shut up and ask.
Yeah, any other questions folks have? No, okay, we can move on then. Okay, so we'll be going over the moving in part, which this will be about forming a lease. So applying to rent, what written leases versus verbal leases mean, and the types of leases you can get. Next slide. So moving in and applying to rent, in general, landlord does not have to give you a reason on why they decided not to rent to you. And the only reason they can provide you with the reason on the denial for renting you a unit is if it's due to your credit check and that you had bad credit, then the landlord has to give you a written notice and give you the contact information for the credit agency in case you either have issues with that or want to check in with the agency on your credit score. And then for application screening fees, they are allowed to charge you for a screening fee that does like a background check on you as a tenant and that sort of thing. But they can charge you more than what it costs them. So oftentimes it costs $30 to get a screening fee, and that's why you pay that $30 for the application fee, is to do this screening of you as a tenant. But they can charge you more than what it costs them.
Now, what if, okay, but you mean that's for the credit check?
That's the screening fee is for a check in general of you as a tenant and your background to see if
And that's free.
It's sometimes it all of the screening, like background checks and all of that costs money, so that's why they might be charging you that fee.
I mean, I was just wondering, because I can do that myself and it's free. So I was wondering why they could charge you, that's why. And for each application, some of them for each application.
Yeah, it is a very, I will add to that, it's a very unfair process of that folks have to pay a new screening fee every time they apply to a new place. And it's something that we've heard before from folks that it is a huge cost burden, especially if you're applying to one unit, more than one unit at a time, to have to pay this fee over and over again. So totally understand it, and it is totally unfair for folks to have to pay this out of their own pocket.
And in some instances that I've gone to, I did it a couple of times, and I went to the location of the place that they were renting. It was already rented, and it was still charging. That's what got me. I said, man, these are crooks.
Mhm. Yeah, that's not right. But we're slowly trying to chip away at all of that, right? That's why we're here to start learning about our rights. Next slide, Janine.
I just wanted to add one other thing too, is that we hear so much about like the different variations. Sometimes it's $25 that people are being charged. Sometimes it's as much as $50, even up to $75. And so the range for what California will allow property managers or landlords to be able, right, to charge for like the rental application process, it varies too much. And these laws, they were written, right? These guidelines, they were written a long time ago before we have, these new kind of digital tools that, really the cost, like you said, Larry, it could be nothing, it could be very little. And so here we are, this is a people's, right, workshop, a people's education on renters' rights. But one of the things that Carla is going to lift up later on is opportunities for us to meet, to organize so that we can change these laws. Some that, were written.
I'm not at home. What's going on?
Oh, some that were written, a long time ago and they need to be changed. So I just wanted to like mention that, right, to folks.
Thanks, Janine. All right. Next, eviction on your record. So if you have an eviction on your record, it is unfortunately on your credit report for 7 years, and they are extremely difficult to remove. When you are applying to rental units, you can submit a written explanation for why you might have an eviction record on your credit report, what happened, and try to explain your situation and your story to these rental companies that you might be wanting to apply to. You can also ask your previous landlord to set aside the eviction judgment, but they don't have to. They don't have to do that. But yes, getting an eviction off of your record is extremely difficult and often happens very quickly. And we're going to go over the eviction process as well later on in the presentation. This is just a starting off. Next slide. So unlawful discrimination. Landlords can't discriminate based on the following characteristics, just to name a few: race, color, religion, sex, your gender identity, your gender expression, your veteran status, your age, your immigration status. They are not allowed to discriminate based on any of these characteristics. It is unlawful. Next slide.
Yeah, I had a question on that. When you mentioned about the, I sort of laughed when you mentioned they cannot discriminate, but it just I don't believe that's realistic, because I believe they still do, just like employment. But anyway, that was just an observation, and it just made me smile. I said, "Yeah, right." Okay, I'm sorry. Go ahead.
No worries. Next slide. The second part to this, so landlords cannot ask questions or advertise based on these protected characteristics that I just mentioned. There is a partial exception, and that's your source of income. Sometimes when they ask for, proof of income on whether you can pay the rent or not, then you need that is a partial exception, and you might need to provide that information. Another exception is if you live in the same house as your landlord. So that means that you are living in a unit where your landlord shares a kitchen and a bathroom with you in the same dwelling. There is contact here for the Department of Fair Employment and Housing available in case, like Larry just mentioned, sometimes it is not realistic, and sometimes there are these unlawful discriminations that happen, and you can report them to the Department of Fair Employment and Housing. And we'll also go ahead and put that number in the chat and their website in case you have anything you want to report.
Now, how would you describe that? I mean, if you were to report it, I mean, I'm just curious because that's sort of like a joke also. I mean, how would you explain that that they say no, they're not discriminating, you saying yes?
I can answer that, Larry, because I faced discrimination in fair housing because I had a service animal and I was also identified as LGBT. So I had set up an appointment to meet at a property, and I divulged that, I said, is there a fence on the property? I have a service animal. And the person became, I tried contacting them a couple of times. He finally got back to me and says, are your animals stinky? Do they go to the bathroom in the house? Which were inappropriate questions to ask. Are you and the other person going to sleep in the same bedroom? Obviously that's that was my partner.
Yeah.
So I ended up calling the Department of Fair Employment and Housing, and I spoke to a representative, and they're very nice, they'll listen, and they filed a claim on my behalf. And then they went out to investigate, and they found that person, they had I guess that person, whatever, sanctioned or whatever. So to answer your question, it kind of seems kind of funny or silly, or you don't know if people are going to take you seriously. But that's the reason a lot of people do not call and don't report these instances of discrimination, because they don't perceive that it is discrimination or it happens to everybody. So that's why it's important.
So otherwise, what was the outcome of your service dog issue?
I ended up renting another property.
Okay.
And the landlord, I guess the landlord or whomever their representative was, got like some type of a fine, or was notated that they were something with the Better Business Bureau or something along that line. I don't know exactly what the sanction was, but they did go out and investigate. They did find that they were at fault because I kept good documentation. So,
okay. No, I mean, but you had recording a service dog. I'm talking about discrimination for race or ethnic background.
I don't fall in those categories. I don't personally fall in those categories.
Yeah.
But if you do experience those things are discrimination. Discrimination is discrimination is discrimination.
Just like an unemployment, employment, the same thing, the same process, you got to prove it.
No, anything, if you make an allegation against another person, the burden of proof does not rely upon the other person to prove that they discriminated against you. It's the accuser's responsibility to prove that they were discriminated.
Yeah, exactly. No, I understand that. Just like my word against your word. Sort of. That's what I think. But anyway, go ahead. I'm sorry.
It's okay.
Thanks, Kara, for sharing your experience with that and giving us an example of, you've called the Department of Fair Employment and Housing, and you've done an initial complaint, and that's great. And like Kara did mention, a lot of the times people are afraid to report these things or don't think that folks are going to listen. But that's why it's important to report things that are occurring to you, housing or otherwise. Otherwise, we get the same rhetoric that, I'm not hearing this problem come from folks, so it must not really be happening, right? So thanks, Kara, for that, for sharing your story with us. We can move on to the next slide, Janine. So types of leases, I'll be going on into some types of leases that you might have as a renter. There is the periodic lease, which is commonly referred to as month to month or shorter, and it's automatically renewed each time your rent is paid, which typically happens at the first of the month, right? Or the third of the month, whenever you pay your rent. That is a month to month lease. And then a fixed term lease is when you and your landlord have agreed that you're going to stay longer than 30 days. And that lease can be termed at 6 months, a year, 2 years, etc. If it's 1 year or longer, it has to be written. It must be written. Your landlord has to give you a copy of this lease, and you are in a contract essentially with this landlord that you will be living in a place for a year. Next slide. So there are special rules to who gets a lease and all of this. So if you're a lodger, which means you're living in a room in a house where the landlord lives, you might have a lease, you might not. Mobile home parks have their own different types of leases that are completely different than folks who are renting a home or a multi-unit apartment. Recreational vehicles in parks, residential motels, transitional housing, and subsidized units, which is public housing in Section 8, all have their own types of leases. And so the leases I'll be talking through today might be different if you're living in any one of these types of housing. Next slide. So a written lease will have how much rent you're paying, when your rent is due, the length of your lease, so whether that's 6 months, a year, or 2, what the property manager or you are responsible for in terms of upkeep and repairs, utilities, and any late fees that you get if you do not pay your rent on time. And like I mentioned, it's required if your lease is 1 year or more. That's a written lease, but you can also get a verbal lease. And that's typically for when you are at a place for less than a year. The only thing that landlords have to give you in writing, if that's the case, is the name, the street address, the phone number of the landlord or whoever the representative is, and how and where you pay your rent. Of course, it's always better to have everything written down and to have a written lease. Like I mentioned earlier, if you are taking a court, if they tell you haven't been paying your rent on time, or that they've suddenly changed things on you, it's always better to have everything in writing in case they decide to want to end the tenancy early or want to kick you out. You have something written.
Now,
But a verbal lease is also allowed if you're there for less than a year.
now, a question.
Mhm.
Now, as far as with the late fees on your rent, I was noticing that recently they sent a new lease to sign, and I was wondering, can they said that after 1 day, otherwise it's due on the 1st, that on the 2nd they're going to charge you a $75 late fee. Is that reasonable? I mean, it don't sound like. I thought you had like 5 days or something like that, before it goes into late fee.
Generally, you have until the 5th of the month to pay your rent there's like a 2, unless it's, I think it is in the city of Fresno or as a standard, maybe you can correct me, that it is, you have like a 2 or 3 day grace period.
That's what I thought, but 1 day, that doesn't seem reasonable. And it seems like unfair.
check your lease agreement. It should
Yeah,
have it written out. Your lease agreement
Yeah,
should have it written out in the lease
Yes.
agreement when rent is due, but then it should also have a clause in there for if your rent is,
Late fee.
or late fees, or by what date they accept it, won't accept it as being paid on time.
okay, and yes, it did, it does say on the first. After the first, it's late.
Yeah, so unfortunately, in the state of California, grace periods are not required. I don't know if there's a special ordinance or clause in the city of Fresno, and it is something I can look into if there's a specific protection for the city of Fresno, but they're typically not required in the state of California. So if it's written in your lease that you have to pay your rent the first of the month, then typically that's just what they wrote. Some landlords are, a lot less lenient, or a lot more lenient, and give you a 5-day grace period, might give you more. But that's just how it is under California law, unfortunately.
Now, this is through management companies, that do it for the landlords.
Right, right.
And
yeah.
the thing is that, Adam, is what if people that are on SSI or A, whatever, that they don't receive a check until the 3rd? And so, because of the limited income, and they're still charged an extra $75 for a late fee because
I can speak to that. I can speak to that because I am on SSDI myself. So that requires you to have a conversation with your landlord when you go in to sign your lease. You need to tell them that your money's come in on a specific date and to work out an agreement with them, hopefully in writing, or to have it included in your lease agreement that you get paid on this date and that your rent will be paid by that date, no later than that date. That has to be a written agreement into your rental contract.
Okay. And now what if you don't sign the agreement?
Then
you disagree with some of the contents.
Then they're not likely to rent a unit to you.
No, I'm already renting. I've been here for about 3-4 years already, but they changed management, and each management has different requirements.
Yeah.
You need to go and have a conversation for clarification.
Uh-huh.
Yeah, that's where I was going the same point as Kara. That would have to be a conversation between yourself and the property management company to try to get that written differently in your lease. You are allowed to negotiate things in your lease if something doesn't seem right to you. You are allowed for it to have it looked at by a lawyer or someone with legal expertise on this and have it changed. So these are things that are totally allowed. So that would have to be a conversation with your property manager to get that, and to get them to understand that you will be paying your rent, but your payment doesn't come in until a certain date. So to amend that 1-day late fee notice.
And how much can they charge for a rent increase?
For rental increases?
Yes.
We'll get into that.
Okay, I'm sorry. Go ahead.
That. Yeah.
I'm jumping ahead.
No worries. I will get to a lot of some of that information as well, and rental increases. This is a somewhat long presentation, and I do want to try to get through all of it. So questions are allowed. I love it. There are designated times for questions as well at the end of each section. So if folks have more questions and can't think of them now, that's totally fine.
I understand.
Next slide, Janine. So security deposits. So how much are landlords allowed to charge you for a security deposit? They are allowed to charge you for an unfurnished unit. They can ask you for 2 months rent on that deposit. So it could be the first month's rent, the first and second month's rent, but they can't ask you for more than that. If it's a furnished unit, which means that it comes with furnishing like a couch, a bed, everything you could need in an apartment, then they can't ask you for more than 3 months rent. They are pet deposits, key deposits, and cleaning fees. That all counts as your security deposit. So all of that can be charged under that same thing towards your security deposits. They can ask you for last month's rent, but that just goes towards those 2 months of rent that they can't ask you more for. So if they're asking you for 2 months of rent, they can use it to cover the first month's rent, the last month's rent, or if you happen to miss a month of rent because you are going through a financial situation, then they can use that. But as always, get a receipt, get everything in writing. Make sure that even if you're paying them with cash, they provide you with a receipt. It is very important that you show that you are paying your rent. There have been a lot of instances in folks that I have worked with that have paid their rent and don't get a receipt or don't get anything written. And then the landlord says, you haven't paid your rent. And then they ask for proof, and it's just like, well, they don't have any proof because they don't have a receipt. So please always get a receipt for your rent, or if you're paying with money order, keep that little extra talent that's attached to the money order as your receipt for paying rent. Next slide. So we're going to continue on to security deposits. So what can a landlord use a security deposit for? They can use it for rent that you owe, for cleaning, if they need to clean the apartment at the end of your tenancy, and damages beyond normal wear and tear. Oftentimes, landlords try to charge you even more for normal wear and tear, stating that, you know, you might have broken something. But next slide, Janine. But they do have to give you an itemized receipts of what they are using that deposit towards. They have to return your deposit within 21 days of you moving out. And they have to, like I mentioned, they either have to send you that full deposit or an itemized receipt of why they couldn't give you your full deposit, and then return any of that remaining deposit over to you. If they don't return your deposit, you can sue them in small claims court and try to get your money back. And the tip that we often tell folks is, when you move out, please make sure you give the landlord a new address to where to send that deposit. Email them, text them, in every possible way you can. Tell them where your new address is, or a PO box, or wherever it is you want to get your deposit mailed to. Because oftentimes they will often say, you know, I don't know where I'm going to send this deposit to, so how could I possibly get your deposit over to you? So please let them know where your next move will be so they can send it out to you. Next slide. So how do you protect your deposits? Walk through with your landlord before you move in. You are allowed to ask for a move-in inspection and have them come with you to point out any visible tear or wear in the unit. And then also do a walkthrough before you move out. So if there were issues that are happening, point it out to them. Make sure that your landlord is there. If possible, take pictures of everything, as was mentioned in the chat. Put everything in writing. It's something I'm going to keep saying throughout this whole presentation. Put everything in writing. And if your landlord refuses to do a walkthrough with you when you're moving in and you're moving out, do it yourself with a witness and take pictures. Take pictures of everything that you see is wrong with the apartment when you first move in. Maybe that's a hole in the wall that they never repaired, or something that they never fixed. You do have you have a week from when you start your tenancy to tell them of anything that's wrong with the apartment so that it's not charged or billed to you. Next slide. So any questions?
Yes, you know, I was gonna ask a question. You said, oh, man. Okay, first question, what is considered wear and tear?
Normal wear and tear?
Correct.
Normal wear and tear for apartment buildings is usually, you know, if the paint is starting to lose its color, if things are beginning to fade just due to time passing by, such as flooring, or things of that sort. That's normal wear and tears. Like if you made a hole in your wall, or if you painted the room a completely different color than what it was when you moved out, that is obviously not normal wear and tear. And you can be charged for things like that.
Okay, and and as far as the if you have like a stove and a refrigerator, and that starts to break down, and you informed them and they haven't done anything about it, and you decide to move and it's still, even though it still hasn't been fixed, can they charge you for that? Yeah.
Or appliances
Yes.
that were there when you moved in?
Yes, and then you had placed, you had informed them that it was breaking down, you know, making noises or whatever, not freezing, the freezer don't work. Yeah, otherwise it broke down.
Yeah, that's normal wear and tear. So that shouldn't come out of your security deposit. Obviously, appliances are expected to show some deterioration over time, because appliances don't last forever. So that is considered normal wear and tear.
Now, if you're living there, should they be replacing it if it doesn't work?
If it's not working and it's something they provided, then yes, you should. And I will go into asking for replacements and things of that sort. But if it's something that's broken, anything that's broken within your apartment that they provided, they should also fix or replace.
Okay, thank you.
Next slide, Janine.
If I may add one thing to that, because it's right on point, I'll be very quick. So in the state of California, your landlord is not required to provide air conditioning or heat under tenants' rights. But they are required to provide repair for it if all the other units, it's like a standard amenity. So they may say, oh, it's not our responsibility. You're not entitled to air conditioning or heating in the state of California. That's a luxury. It's not our responsibility to take care of it. If other units on the property, if it's a standard amenity, everybody utilizes the same thing, even though it's not required by the state to provide it, they are required to repair it.
Okay.
Thank you, Kara. And to that point, in the state of California, air conditioning is a requirement. Heating is not, and it's something that I mentioned in this PowerPoint, but I did want to make that differentiation that in the state of California, landlords are required to provide air conditioning. Air conditioning is a requirement, but heating is not. And that's something that we are trying to change, because we know that heating should also be something that's available to folks as it does get cold. Yeah, just wanted to make that point and that clarification. Next slide.
Sorry, can I ask a question on that?
Yes.
So if there's an apartment complex, if it's a multiplex and say like 2 out of the 4 units have an AC heater and one of them breaks, is the landlord then required to repair that?
Repair the air conditioner?
Yes, if it's not in all of them, if it's only in like half of them, would the landlord still be required to repair it?
Yes, they have to repair the air conditioning. That's something that has to work in the unit. It's part of what makes a unit habitable in the state of California. And I would even say that the half of those units not having air conditioning means that the landlord is not complying with the law, because air conditioning is a requirement, and cooling is something that units have to have and has to be working.
Okay, thank you.
Mhm. All right, so living in the unit, we'll go over paying rent, rental increases, the landlord's right to enter, and then more into unit condition and repairs. Next slide. So paying your rent. So your written lease should include when your rent is due, where you pay it, and how you pay it, whether that's in cash, as a check, a money order, online. Your lease should detail all of this information. Some tips we tell folks is to obtain a receipt each time you pay rent in cash. Oftentimes it's hard to prove you paid your rent if you're paying it in cash, so please get a receipt. Even if that means that you write it and your landlord signs something that says so-and-so has paid their rent for the month of February, that's a receipt. Send payments by certified mail if you can, or if it's through a cash or a check that you have to mail out, send it through certified mail to show and prove that you sent in your rent. And keep copies of returned checks. Always keep copies of everything. Next slide. So paying your rent. Landlords can charge late fees as long as rental agreement provides for it. That was something we just talked about, and they can provide for it. There was an exception during COVID-19 rent debt, where if you had been behind on your rent for months, starting from March of 2020 up to about October of 2021, they could not charge you a late fee if the reason you were not paying your rent was due to COVID and the effects of COVID. Landlords can require you to pay in cash only if your check or money order has bounced in the last 3 months, so they could not cash in the check or the money order that you gave them, and your landlord provided you notice that you will have to pay cash that month or from then on out. As always, I keep repeating this, make sure to get a receipt. It is important to prove that you paid your rent. It is super important to have proof. Next slide. So limits on rent increases, like we were talking about. If you're on a fixed term lease, so if you're on a lease, they can increase your rent during that term of the lease, unless it's stated in your lease that they can raise it twice a month throughout the period of your lease. But if it's not included in there, then they can increase your rent. So whatever your lease says for that year is what you pay for the whole year. They can increase it anytime between them. And they can also increase your rent when you are renewing your lease. So let's say your year is up with the current lease you have, they can give you a new lease with a higher rental price when you're signing that new lease or when you're renewing your lease. Then they can raise your rent. If you rent month to month, your landlord can increase your rent, but has to give you notice of this. They give you 30 days if the increase is 10% or less, and 60 days if it's more than 10%. This is general information, but of course, the city of California has a law put in place that I will talk about as well, called AB 1482, which states that they can't raise it over 10%. So that 60 days notice this PowerPoint was also written sort of prior to AB 1482. So 60 days notice was typical for rents over 10%. But in the state of California, you can't raise the rents more than 10%. And then subsidized rent, your rent can increase if your income or household size has changed. For example, a lot of Section 8 folks, if they have more income coming in, or if their household is less people or more people, it can change depending on a lot of that information.
I'd like to ask a question here.
Mm-hmm.
When I moved into my apartment, I was required to do a 1-year lease. And then after the end of that fixed term lease. Even though I requested, I said, I'll sign another 1-year lease. They moved me to a month to month. So my question with the month to month is, can they, with rental increases, is it a one-time 10% increase in a 1-year term? Or can they raise the rent 10% every 30 days or every 60 days? How does that work? Do you know?
Yeah, so they can, and Janine, can you go over to the next slide really quickly? Because it goes into AB 1482. So it's 10% throughout all of that 12-month period, all of that yearly period. It can't be over 10% for both increases.
Okay, so in a 12-month time span, they can't raise the month-to-month rent above 10% or the current 8.8 in an entire 1-year term. Is that kind of what I'm understanding?
Yeah. Mm-hmm.
Okay, thank you so much. I appreciate that.
Yeah. And if anyone has any other questions, please interrupt me. But unfortunately, AB 1482 applies to many, but not all renters. Under AB 1482, landlords can increase rent twice in those 12 months, like I just mentioned, but the limit is between 5 to 10% every 12 months, depending on the economy. Right now, currently in the city of Fresno, that percentage is 8.8, but these percentages are always changing. It could be more, it could be less. So in the chat, I've put ahead this tenant protection calculator, where you put in what your initial rent is, and how much a landlord would legally be allowed to raise your rent based on this 8.8%. Next slide. And so landlord's rights to enter. A landlord can enter without written notice only for emergencies, when a tenant has moved out or has abandoned the unit, or if the tenant is there and agrees to let them in. So if you're there and your landlord knocks on your door and is like, hey, can I come in? And you say yes, then they can come in. Other than that, a landlord can only enter your apartment if it's written within 24-hour notice. That has to include the date, the time, and the reason why they want to enter your apartment. The reason why they might want to enter your apartment can be because there are repairs or improvements that need to be done. Maybe you put in a request because your shower is broken, so they're going to give you a 24-hour written notice to come into your apartment. They can also ask to come into your apartment if they want to show the unit to prospective tenants, purchasers, or workers, or they can also enter your unit 24 hours written notice if it's by a court order. So if they got a court order that they have to enter your apartment, they still have to give you that 24-hour written notice, but then they can come into your apartment.
So I want to speak to really quick to being a student living in the student adjacent housing. If you have a roommate, this happened in my situation. If your roommate puts in a work request order and gives them permission to enter, but they don't tell you, they still can legally come into the unit with, even if you didn't know, and they can come in to do repairs to that person's part of the property. So I had workers come into my home and I asked them to leave and they refused. If you ask them to leave, they have to leave. But one of the biggest things is, like, I'd ask them to leave, but they said, oh, your roommate gave permission to enter. So it has to be a communication between both parties. And that's kind of where they have a gray area and they kind of overstep their bounds in student housing.
So you actually can tell them to leave?
Yes. If it is a non-emergent issue and you don't feel comfortable with the person being in your house and you did not have notice of entry, even if your roommate has a guest or a friend over and you don't feel comfortable with them being there, you can request that they leave. And if they refuse to leave, then you can call law enforcement and have them removed, even if it's a worker or property management or someone in your home without your permission.
what if they don't come on the time they put on the notice and say they're late and you didn't hear the door and they just walk in like that, do they have the right to still walk in even if they're late?
Yes, because either they gave you the 24-hour notice. I will say that, like I mentioned here, it's a necessary or agreed upon repair, which means that it's a repair that you both agreed needed to happen. You need someone to come into your apartment, and they give you an estimated time to come in. I would say that because they gave you 24 hours notice and they gave you the date and the purpose of entry, they can come in. And also, if your name is on the lease, like Kara said, her roommate gave permission for them to enter the apartment for any necessary or agreed upon repair, then they can come in. The only way that they would be able to come in without a written notice is, as I mentioned, if it's an emergency, if a tenant moved out, or if you're there and you agreed to let them in while you're there, that's when they don't have to provide a notice. But other than that, if they gave you notice that they were gonna come and try to fix something, then they can walk into your apartment.
But just to be sure, you can still tell them to leave at that time?
From what police department told me, yes.
Because I have an issue, well, with me, the thing is, I usually wear a cover on my head. And so there was a time where I didn't hear the door and this guy just walked in. And I told him, you can't just walk in like this. You have to call me or let me know. I didn't know that they were coming. I guess my husband seen the notice and he totally forgot to tell me. But that was an issue that I had where they just randomly walked in and, I wasn't covered.
But they had given proper notification to your husband. They don't need to notify every single person. They can post a notice in a conspicuous place. So that can be on the outside of the door or something. So it falls into the
Sometimes they put
communication.
a paper and, you got neighbors sometimes that like pulling papers out of your door. So sometimes they just stick a paper that's not all the way inside your apartment and somebody might just pull it out. That might be one of the things.
But they still gave notice. They don't, after they give notice, what happens to that notice after they posted it? They know that they posted it in a conspicuous place or an easily seen place. So if someone comes and takes it and you don't get it, then they're not liable. They've given notice.
Okay, but you could still tell them to leave at that moment they come in.
Yes, and if you do not feel comfortable, you say, I'm sorry, I don't feel, sorry, I request that you leave the premises right now. And if they refuse, if it's an emergency, they have every right to be there.
Yeah.
But if it's just like like a broken door or something like that, and you say, I don't feel comfortable with you here, or like my husband's not, or, to say, I don't feel comfortable with, maybe a man being in the house while you're home alone.
Yeah.
You can request that they leave. And if they don't, then you can call the manager or you can call the police and have the police remove them.
Okay, good to know. Thank you so much.
You're welcome.
Next slide, Janine. So like I mentioned, landlord's right to enter can only enter during normal business hours, of course, unless it's an emergency or the unit is abandoned. And when I say emergency, it's, there is a violation that makes it not habitable. Your water is overflowing and can cause a flood or damage to other buildings. Normal business hours constitute when the manager's office doors are open, or usually typically from 9 to 5. Those constitute normal business hours. 8 to 4 is what folks usually constitute as normal business hours. Like Kara mentioned, they cannot enter to harass, whether that is your landlord, the manager, property management company cannot enter your house to start to harass you. That is against the law. There are different rules for subsidized units. Again, Section 8, public housing, that they have completely different rules. But again, a landlord has to give you notice if the unit is for sale, if they are planning on selling the unit, or showing your unit, they still have to give you notice for that. Next slide, Janine.
I have a question about normal business hours.
Hey,
Is it
Kara,
mon-
I was gonna make a note in the chat, just that,
Okay.
directly to you. So when, we come to the questions part, sorry to interrupt you too, I apologize. But, when we come to the questions part, I was gonna make sure and lift these up for Carla.
And I'll answer that one now. And it's between the hours of 9 to 5, Monday through Friday. Those are normal business hours. So weekends are not constituted as normal business hours. Usually it's a Monday to Friday type of thing. So living in the unit, so conditions of the unit must have a working toilet, wash basin or bathtub or shower, has to have a working kitchen with a sink, natural lighting in every room, operable deadbolt locks on the main entry door, safe fire or emergency exits leading to a street or hallway, and working smoke detectors and carbon monoxide detectors. If these things are not in your home, you are allowed to contact code enforcement. That's their 311 number. If these things are not working, if your landlord refuses to fix them, or if you go into a unit and you see that some of these things are missing, let the landlord know, and probably don't rent that unit, because it is missing the conditions that make a unit habitable and safe to live in. Next slide. It must also have effective waterproofing, weather protection, including windows and doors. Plumbing, gas, heating, electrical systems all have to be in working order. Floors, stairways, and railings are in good repair. Clean and sanitary buildings and grounds, which means that the building does not have mold. Heat, I'm sorry, and I totally switched this up earlier. I said air conditioning was required. It's actually not air conditioning that's required, it's heating. Heating is in the state of California required to be in every unit of the household. But to your question earlier, someone asked about air conditioning. If that air conditioning was provided by them, then they have to fix it, regardless of whether it's required or not. They have to fix it just because they were the ones who installed it and put it in the unit. But again, I'm sorry, and I mixed those up. So every unit has to have heating, not included air conditioning. Next slide. So what are your responsibilities as a tenant? Keep premises clean and sanitary, use and operate gas, electric, and plumbing fixtures properly, not destroy, deface, or damage the property. So tearing down walls, making huge holes. I know some of us hang up portraits, that's fine. I mean, I'm talking about damage that is just, you can't hide. And then use the premise as a place to live and use rooms for their intended purpose. If the tenant has caused the unlivable condition, the landlord does not have to repair it. That does not fall on the landlord. If you're using your apartment in other ways that are making it uninhabitable, then they don't have to pay for those repairs. Next slide. So what do you do if there's a problem with the conditions of your units? Basic things is you send a landlord a written request, send them everything in writing, as I previously said, send in a form that you can prove that they got it, and ask them to respond back to that letter you sent them. Ask them, please respond just to verify that you have received my request. Send them a request for what is wrong and what needs to be fixed. Give landlord time to respond and fix this issue. If it's not an emergency, typically they have up to 1 month to alleviate the problem within your unit. Next slide. If they don't respond or make the repairs, you can consider doing the following. But we do tell people to be careful before doing any of these things, just because they do come with a risk of red tagging, of evictions, of lawsuits, of retaliation. There is just a lot that can happen if you decide to pursue any one of these, but these are illegal to do. Contacting code enforcement or your building inspector. That's the 311 number in the city of Fresno. You can contact them, let them know what's wrong. The city sends in a code enforcer to check out what it is that's wrong. And then they'll talk to the owner of the property and tell them, you have so and so much time to fix this issue. We're gonna come back and check. If you haven't fixed this issue, we're gonna fine you and you have to fix the problem. And a lot of people do contact code enforcement, and oftentimes that folks get the things that they need fixed. You can withhold your rent until they make the repairs. This is a riskier one and folks have done it. So red tagging is like blacklisting or telling other landlords like, don't rent to this person is causing trouble. And so it makes it hard for you to find another place to rent, just because other landlords have said, don't rent to this person. They're going to make it really difficult as a tenant. That's red tagging. So you can withhold your rent. Folks who have done this before have unfortunately faced evictions. Withholding rent means that you tell your landlord, if you don't repair these things within this amount of time, I'm not paying you rent this month. Of course, as we stated earlier, the law is extremely difficult and complicated to navigate. And a lot of the times this doesn't work. So we always recommend talking to a lawyer before you decide to withhold your rent. You can pay for the repairs yourself and then deduct it from the cost of the rent, or tell your landlord to reimburse you for the cost of the repairs. If you're doing them yourself, you can sue the landlord or you can move out without notice. But that, like we mentioned, that be careful doing these things. Moving out without notice can sometimes put bad things into your record. You may have broken your lease if you just move out without notice. And that means that they can charge you for the remainder of your lease, or just not letting them know can have some fees applied to that. So you can do these things, but of course, like we said, be careful doing these things, and always talk to a lawyer before you decide to withhold your rent, or move out or sue your landlord. Next slide. So questions, I'll pause here for questions, and I'll also check the chat.
I have a question.
Mm-hmm.
So kind of like I noticed like an increase in my bill during for PG&E during the winter months. I had my AC going for like the summer, and then like once we kicked it over to the heating, I realized that our payments were going from like $70 to $80 to like $340. And so do you think that could be because of like the windows and like the installation of the house, and are they required to fix that and take care of that, or is that something?
Mm-hmm. So for weatherproofing and all of that, yeah, like Kara said, rates are usually higher in the winter because it gets so cold and people ramp up their heating. Unfortunately, that's not really a responsibility of the landlord, as long as they provide windows and things that can close and shut properly and the doors shut properly. They are not legally required to do any additional weatherproofing.
Okay,
Unless it's causing some type of health violation or health concern, or there is just something in the walls that is making it unhealthy for folks, then I would say that's a problem for the landlord. But typically, that's not an issue for the landlord to take up.
Okay, I was just curious because I feel like because of like the way that the windows are, it's kind of like an older house. I feel you get like a draft from the windows and like the door seals. So like the rooms with doors or have lots of windows are colder than rooms that like are stagnant and have no form of exit.
Yeah. Yeah. And I totally understand what you mean. Like weatherproofing and all that is something that should be required of landlords to have, but it's not.
Okay. Okay. Thank you, Carla. I was just curious.
Janine, you had a question?
Yeah, a couple of comments and then also an ask to you, Carla. So one is that I know that their PG&E has like this weatherization program for folks who are in like fall within like a certain income guideline. But I don't know if that could be extended to a property owner. So like say in Madison's situation, if she felt comfortable finding out from PG&E, like could her property be eligible? And then the landlord may be also agreeable to it. And then PG&E does that weatherizing, you know? So that was kind of like one kind of a curiosity on a question, if that is something that could be working, could work.
So having PG&E pay for that weatherization program.
Yeah, if a person is income eligible, then they do it at no cost. They come out and do like weather stripping and, you know, different things to make the property more, I don't know, like to keep the PG&E, like the amount of energy down.
Like energy efficient.
Yeah.
I'm definitely going to be searching that up right now and be checking that out because I definitely want to see like what's going on, how we can take care of it. So thank you for that, Dr. Janine.
Yeah, I think this is also brings up an important point about the differences between renters and homeowners, because as renters, we might be eligible for certain things, right? Or we might have needs and our income might be eligible, but because we're renters, there are certain things that we don't get to have access to, whereas if somebody were like a homeowner. But I'll also share the information for you too, Madison. And then it may be worth it to try.
Yeah, most definitely. Thank you.
There was something I wanted to speak to also with the PG&E. So I lived in the student adjacent housing, so I rented per room. One of the issues that a lot of the other tenants were having, it was two issues. They only require one person to be listed on the utility bill. And so say you have a roommate that likes to play a lot of video games or turn the AC down to like 58 degrees. And then they move out suddenly and you get stuck with a huge bill. Whoever name is on the bill is the liable party. So I always recommend that when you move in together, if you're going to live in that kind of a roommate situation, all parties are listed as responsible on the bill, and you can do that with PG&E. Secondly, some of the apartment complexes will say that they require you to utilize their own billing system for energy. They'll tack on it's like a $50 fee, and then they'll add that money into your rental amount. That opens up a lot of problems because the management companies don't divulge you don't get a bill. So what PG&E told me to do is if your landlord is requiring you to do that, you can call PG&E and say, I just want to have my own account. So your landlord can't charge you, to add you can sign up to have your bill included in your rent, but you're not required by the law. Because when we did our tenants' rights day, we had a guy that got stuck with a $3,000 PG&E bill. So.
Thank you. Thanks everyone for your stories and for your expertise. That's what a people's learning is all about, is all of us coming together and having our collective experiences and expertise come together to learn from one another. So thanks everyone who shared today, who's asked questions, who's has hopefully learned some things about tenants' rights today. I'm gonna skip the last section of the PowerPoint, which is just the moving out section, which goes into tenants notice, landlord's notice, and eviction process, because we're a little short on time. But there is a recording that one of my colleagues did, who's a former housing attorney, did regarding this PowerPoint. And we will also be sharing resources and everything, and where to get help if you are faced in a situation where you're having issues with your landlord. So this is not the end all be all conversation. We'll keep having these conversations. But for now, I'm just gonna skip through the last section and go to some COVID rent.
No, not that COVID.
Just really quickly, just some rent and utility assistance information for y'all. If you need help applying for past due rent or utility assistance, please call the Jakara movement. Their number is on the screen, but it's 559-549-4088. If anyone here happens to live in the Eastern Coachella Valley, or yeah, if you happen to live in the ECV, you can also call Lift to Rise at 442-334-7923, or if you know anyone who lives in the Eastern Coachella Valley, and can use that information. There's also the eviction protection program in the city of Fresno that helps folks with, if they're facing evictions, if you've been served an unlawful detainer, if your landlord has said you have 30 days, 3 days to move out. There is a city-sponsored attorney program where you may qualify to get an attorney at no cost or a low cost. The flyer is here on the screen. You can fill out an application online or by calling 559-621-8400. We'll also put the link to their website in the chat. And then just lastly, some legal aid orgs in Fresno. There is CCLS, which also provides legal advice for folks going through not only housing, but other issues as well. And their phone number is 800-675-8001. For CCLS, you do need, for both Central California Legal Services and for California Rural Legal Assistance, you unfortunately do need a social security number. So if anyone in your household has a social security number and can apply this way, you can. And both of these are based in the city of Fresno and can provide legal help for free or no cost. Yes, and they are income based. So depending on the income, which is 80%, 80% of your, if you fall within the 80% range of low income households, then you can qualify for legal aid assistance in Fresno. Next slide. So really, the last thing I'm gonna talk to y'all about today, again, reiterating the day is closer. Friday, March 4th is right around the corner. And as always, we're asking people to join us in front of City Hall for a press conference demonstration for safer, affordable housing. We had a conversation last week, a really great conversation, about folks having difficult living situations and continue to have difficult living situations, and the city does not seem to be doing anything about it. So we will be there March 4th from 11:30 to 2 in front of City Hall. We can pay for parking. We will have food. We will have merch. We are trying to make this event as accessible as possible to folks. So please come by. We'll have, if you can't make your own sign, we'll have materials there for you to make a poster, and some resources for folks as well. If you can't call Jakara this week, they will have a table there to help folks with rental assistance and utility assistance right there and then. So please come out, show some support, and let's hold City Council accountable to the jobs that they're supposed to be doing and the constituents that they're supposed to be serving.
Is it free food?
Yes, there is free food.
I had to ask.
Yes, we will have free food, everything is free. We never ask folks to pay for anything. So please come by, and like I said, we're trying to make this as accessible and as the less cost burden we can to folks to just please attend and use their voice, which is often a luxury for a lot of folks. We know that, some folks work during this time, have children, but we are trying our best to accommodate folks, and have folks be there without worrying about hoping to not worry about other things besides using their voice and advocating for housing on that day.
Well, I'll invite people in my network.
Sounds good, Larry. I hope to see you there. I hope to see all of you lovely people there using your voice and making some noise.
Okay, and you guys have a smile of a day.
Thank you. Any closing words, Janine, before I hop off?
Oh, I was gonna say peace and love.
Hey, peace and love. That
Yeah.
sounds good to me, Larry.